Wednesday, a federal district court in Missouri ruled to immediately stop the Biden administration's radical rewrite of Title IX. A coalition of red state attorneys general, along with our good friends at Alliance Defending Freedom, and an Arkansas high school athlete, Amelia Ford, they all joined forces to sue the Biden administration over this illegal rewrite of Title IX. And notably in all of this, the judge who sided against the Biden administration's attack on girls and women was appointed by Democrat President Bill Clinton. We're here to discuss the good news is Missouri Attorney General Andrew Bailey. Attorney General Bailey, welcome back to Washington Watch. Always an honor.
Thank you so much for having me on.
Well, congratulations on yet another big court ruling. Bottom line, what will this decision do?
Well, this is an important step in protecting women's equality and the sanctity and integrity of women's sports. And it's not just about the athletic competition itself. It's about the space women need to prepare for and after an athletic competition. So bathrooms, locker rooms, hotel rooms for overnight travel, all of those things that President Biden wanted to allow men to intervene in, we put a stop to it. And again, this is as much about the policy position of protecting women's equality and the sanctity of women's sports and safety as it is about the legal aspect, which is that nothing authorized the president to amend Title IX. For the last 50 years, it stood for the proposition that women have equal access to sports. President Biden, through the stroke of a pen, sought to override that and allow men into women's sports, thereby perverting the plain text of the statute. I'm proud to say we delivered a win on this one, and we're going to keep fighting on this issue.
Well, and so far, from my count at least, the Biden administration is 0 for 5 now in court decisions along these lines. And I mentioned it in passing, but how notable is it that a Democrat judge ruled against the Biden administration?
Well, at the end of the day, I think it's notable because the plain text of Title IX could not be more clear. And so not even a Democratic appointed judge could go so far as to pervert the law and authorize the executive branch of government, the president of the United States, to undermine what Congress had put into place. That violates our separation of powers doctrine. And again, a plain textual analysis of the statute precluded the act that the president took. And yeah, look, this is a nationwide issue. I remember when we held our press conference, when I partnered with my colleague Tim Griffin in Arkansas, General Griffin said, who could possibly be for this? Like, who's on the other side of this issue? And I think that's why you see across the country so many different courts striking down this Biden attack on women and women's equality.
Yeah, I totally agree with you. And it is so true. When you look at this stuff, you scratch your head saying, how can anybody be supportive of this nonsense? Tell me this. You said that this is going to have some national ramifications. I think you're spot on with that. But the Biden administration's Title IX rules were set to take effect literally next week. What does all of this mean, practically speaking, as we go forward?
Well, it prevents that perversion of the law. It prevents the Biden attack on women's sports and women equality from going into effect, and it keeps in place, a landmark in the fight for equality for women that has stood for 50 years in the sediment of case law that has built up interpreting that statute. And again, this has been something that's been celebrated in past generations, has given a women an opportunity to compete in their own athletic competitions and the safety and security of their own locker rooms, bathroom facilities, and hotel rooms as well. And so this is a monumental win, and I think it'll stay in place because at the end of the day, the president can't rewrite law without an act of Congress, and Congress is absolutely not going to undermine 50 years of women's equality.
Yeah, absolutely. Well, in addition to the Title IX lawsuit, you are also in a legal battle against the state of New York over their lawfare against former President Donald Trump. Tell us the latest on that.
Yeah, we filed suit to prevent a rogue prosecutor and collusive judiciary in the state of New York from hijacking a national presidential election. This lawfare against President Trump is poisonous to our democratic process, antithetical to who we are as an American people. One can look so far as the not only the charging document, but the trial process, the gag order, and the conflict of interest by both the bench and Barr in New York and realize that the conviction is replete with constitutional error. But Alvin Bragg's objective was never to obtain a legally valid conviction. It was always to take President Trump off the campaign trail. Now, the problem is that deprives Missourians and all Americans who vote, that deprives them of access to a presidential candidate and the ability to hear from a presidential candidate. These are basic constitutional rights that Missourians have to participate in a national election on equal footing with other states. And the founders contemplated that there would be disputes amongst the states, and they codified a method by which those grievances could be redressed in Article 3, Section 2 of the United States Constitution. And so we filed an original action, Missouri versus New York, at the Supreme Court. The Supreme Court took notice and demanded that New York respond. That's where we are now, and we're preparing a reply.
So where does this go from here? So the argument that you gave that the gag order and so forth prevents Missourians from being able to hear what they need to hear from a presidential candidate, that provided adequate standing. Is that correct?
Yeah, that's the argument we're making. Certainly, we have a statutory process by which the political parties in the state of Missouri select electors who then go to a national convention and cast their votes for president. Certainly that's true as well with our electoral college. And so those electors have a job to do under Missouri state statute, and they're being deprived of their ability to do that job by not only the fact that President Trump was tethered to a Manhattan courtroom for weeks on end, potentially sentenced to prison and thus taken off the campaign trail permanently, but certainly gagged under the gag order and prevented from discussing political topics that are of interest to Missouri voters. I have constituents all the time reach out and say, hey, can we still vote for President Trump? What's going on with this? Can he still appear on the ballot? Can he serve as president if he is convicted? And that's another one of our arguments. It's called the Purcell Doctrine, and it stands for the proposition that courts should stay out of any case that could obfuscate an election. The Manhattan District Attorney's illicit witch hunt prosecution of President Trump is absolutely obfuscating this national presidential election, and it's depriving Missourians of their rights. And that's why we're fighting so hard at the Supreme Court.
Well, Attorney General, it is always great to have you on Washington Watch with us. And again, as I say to you time and time again, we are so grateful for the bold stance that you take. As far as timing, what do you expect next? When is this when do you expect something to happen here?
Well, Missouri is going to file our response to New York. New York has said that Missourians' voices don't matter in an election process and that they get to do what they want. We reject that argument. We will articulate that in our responsive briefing. That should be on file at the court next week.
All right. Fantastic. Again, Missouri Attorney General Andrew Bailey, thank you so much for joining us. God bless you. Have a great weekend.
God bless you. Thank you.